Good morning, citizens. Welcome to the September 26, 2024 called meeting of the Board of Adjustment. We are now in order. We now have a substitute seated, and first item is approval of the minutes.
I move that we approve them, both of them, as written.
Mr. McClendon has moved that they are approved. Need a second? Second by Mr. Uhas. All in favor?
Aye.
They are approved. Next item is old business. Is there any old business? Hearing none, we're going to move right to our variance. Mr. Golden, you want to start?
Mr. Eads, can you hear us?
Yes, I can hear you fine.
All right, if you want to go ahead and do your quick spiel before.
Spiel. Absolutely. Good morning, board members. I apologize. I had some transportation issues this morning. This is a variance application, which is a quasi judicial hearing. The applicant is entitled to a fair and impartial decision-making body. Essentially, what that means, testimony must be under oath and subject to cross-examination, and your votes today should be based solely on the competent, substantial, and relevant evidence that's produced during this hearing. I need to ask you a few questions as a board to make sure you're fair and impartial. Does anyone have a financial interest in the subject matter of this application?
No.
Hearing none.
Okay. Does anyone have a business or family relationship with the applicant?
No.
Hearing none.
Brian and Marianne Beck. The property is located at 101 Northeast 53rd Street. We're located to this property to assess this variance application.
Yeah.
Mr. Eads, you're in and out a little bit.
Has anyone made a East 53rd Street to assess this variance application?
No.
Not that it's prohibited, but I don't believe anyone has.
I have not.
Any conversations with staff about this variance application prior to today's hearing?
No.
That would be a no from everybody. May we proceed now?
With the applicants. Has anyone had any conversations with the applicants concerning this application?
No.
Hearing none.
All right, the applicant has the burden of proof evidence that's offered during this hearing that they meet the 4 criteria that's in your agenda packet. In order to obtain a variance, there must be a favorable 4/5 vote. As I stated earlier, all those who wish to provide testimony must be sworn in, and they will be subject to cross-examination as well as to questions from the board. We will proceed by first hearing from staff, which I understand will be Mr. Golden, and then we will hear from the applicant, then we will hear from all other parties who have questions of me before we start.
Okay, we'll go ahead and swear in. Anyone, if you'll come.
Okay.
Or whoever's going to speak, if you'll come forward. Solemnly swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Everybody in at one time? Mr. Golden, take it on.
All right, thank you. Let's see. All right, first application for variance will be for a side setback encroachment at 101 Southeast 53rd Street. Background on this request is, then again, the property is at 101 Southeast 53rd Street, tax parcel ID 249DK008. It is zoned R6 residential. The applicant is requesting a variance to encroach 3 feet into the 8-foot side setback. Section 8.4.1 sets the interior side setback at 8 feet. There is a provision in our ordinance that allows certain projections into the side setback, such as sills, belt cornices, cornices, buttresses, ornamental features, and eaves, which are allowed into the setback area, provided such projections do not exceed 24 inches or 2 feet. Also, open or enclosed fire escapes, outside stairways, balconies, mechanical equipment, which serves the principal structure and other necessary unenclosed support structures may extend no more than 4 feet into a required setback. Here's an area map of the property. It is south of East Oak Island Drive, highlighted in blue in the middle of the screen. Here is a zoning map of the area. Like mentioned before, the property is zoned R6 residential. There is other zoning districts such as CB, community business, CR, commercial recreational, and more R6 surrounding the property. Here's a picture of the house from December of 2023. The red circle indicates the area which is being requested to encroach into the side setback. As mentioned before, there is a provision that allows stairs to encroach into the side setback. Here is a site plan provided by the applicant indicating the dimensions of encroachment. The covered steps will be 5 feet from the property line, which would be a 3-foot encroachment into the side setback. I'll go over the standards for the variance. Chapter 160D-705D warrants variances when an unnecessary hardship would result from the carrying out the strict letter of a zoning regulation. The Board of Adjustment shall vary any of the provisions of the zoning regulation upon a showing of all the following. Number one is an unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. Number two, the hardship results from conditions that are particular to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. Number three, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. And number four, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. As Mr. Eads stated, a variance requires a concurring vote of 4/5 from the board in the affirmative. That's all I have. If you have any questions, I'm open to them at this time.
Mr.
I have some questions.
I think
Chairman, may
Mr.
I just,
Mr.
The
Eads
board
is,
want to ask Mr. Golden any questions?
Mr. Farley, Mr. Eads has a
Second.
statement, I believe.
Mr. Golden, it looks like pages 11 through page 26 of the agenda pertain to this variance application. Is that correct?
Yes, sir.
Would you like to introduce that as Exhibit 1?
I would.
Are there any objections from the applicant?
No.
No?
Mr. Chairman, I recommend we accept without objection is 11 through 26 of the agenda packet.
It's 24, not 26.
No, it'd be page 24.
It is page
Trees.
24, Counselor.
Okay, I'm looking at my digital copy, so I could be wrong. Yep, you're right. Sorry about that. I recommend we accept 11 through 24 into evidence as Exhibit 1.
Is there anything else?
Mr.
So for the record, is that exhibit accepted?
Golden, how many,
Yeah, I'll move that we accept that, those pages as
All in favor?
Aye.
Aye.
That's approved. Go ahead and reset those pages.
I have,
Mr. Golden, how many slides is the PowerPoint?
I believe. The first 9 slides are for the first item.
Okay. Would you like to offer that as Exhibit 2?
Yes, sir.
Are there any objections to receiving the PowerPoint that was just displayed in evidence as Exhibit 2 from the applicant?
No.
No objection from the board.
move we accept those
We have a
items
motion.
as Exhibit 2.
We have a move to accept those items.
Second.
Seconding. All in favor? Those are accepted.
All right, now do I get to ask my questions?
Now, can we ask our questions, Counselor?
Yes, sir. Thank you.
Thank you. Any questions for Mr. Golden?
I do have some questions. What's being asked here, the variance is to just put a roof over the existing stairs, is that correct?
I would like the applicant to justify their request.
Okay. Assuming, and we'll get more information as to whether that is exactly what's being asked for, but assuming that is, what other encroachments into setbacks are generally allowed under the ordinance? I mean, are stairs, front stairs, for example, are those allowed into encroach into the setback?
Yeah, section 8.14.8 allows for fire escapes, outside stairs, balconies, mechanical equipment which serves the principal structure, and other necessary unenclosed support structures. All those mentioned are allowed to encroach 4 feet into any required setback.
Okay, well, open or enclosed fire escapes outside stairways and other necessary unenclosed support structures. So, are we interpreting then open or enclosed fire escapes to the enclosed only to apply to fire escapes?
Specifically how the ordinance is written. I mean, in this instance, this isn't being considered a fire escape. This is an unenclosed outside stairway would be
Right.
allowed. And this is being,
But I'm just wondering, you know, if this is what the ordinance reads. I mean, the enclosed could also apply to open or enclosed outside stairways, open or enclosed balconies, open or enclosed mechanical equipment, which serves the principal structure.
the interpretation of our department is open or enclosed fire escapes as one entity, then outside stairways as another, balconies singular as another. And then, because you can't have open or enclosed mechanical equipment. Balconies are,
Well, I mean, you could certainly have a roof over mechanical equipment. Would you consider that enclosed mechanical equipment if there was a roof over it?
yes, unenclosed. Unenclosed means open.
So if I have a roof over the air conditioner, then that's not allowed.
Correct.
So if you have, all the sides are open except there's a roof over top, that means it's enclosed.
Yes, because we look at setbacks at an aerial view, and unenclosed, it would be no roof, no, open.
Well, what's your interpretation of it being sheltered? That's what I think. A roof just supplies shelter, like a carport. A carport's not an enclosure.
It is an extension of, shelter's not included in this definition in this ordinance section. So specifically, shelter as a definition wouldn't come into play in this instance.
So a front stoop, for example, that extends into the setback can't have a roof over it.
No, sir.
Does an awning count as a roof?
An awning counts as a fixed awning is a part of the footprint of a building. It would need to meet setbacks.
But a removable awning,
Folding
a
cloth?
cloth awning, for example, one that could be removed, or a retractable awning, for example, that would not be considered.
That would be looked at as a temporary addition. It's not affixed in one position. It's retractable, it can be moved, so that's not an affixed portion of the structure. But this would not be retractable in this instance.
Right, I understand. Well, we don't know that because we're not 100% sure yet what they're asking for, but, okay. If I could ask our attorney whether it is reasonable that open or enclosed could apply to all of those items listed there.
It's a good question, but I think at this point, staff has made a determination that this particular application or this particular request does not meet the exceptions. And I think that bears on criteria 4 about meeting the spirit of the ordinance. We're not here on an appeal from staff determination. We're here on a variance.
Exactly.
So,
All right, thank you.
That explanation was satisfactory,
It was,
evasive.
no, it was exactly correct.
Okay, and it should be mentioned that in the event of a fire, the applicants are not barred from using these front steps to escape.
Or the side steps, right?
Okay, this is going to be very interesting.
All right, thank you. You've answered me.
Thank you.
Any other questions?
I don't think so. Should we hear from the applicants at this point of the hearing?
Mr. Chairman, the applicant has the right to cross-examine Mr. Golden. I would recommend we give the applicant the opportunity to ask Mr. Golden any questions.
Oh, okay. Would you like to ask him directly anything, the applicant?
Okay. Thank you.
Thank you. The applicant may take the stand now. We already have your names and street address, so we can get right to it.
Yes, so sounded like you might want a little clarity on what we're doing here. Is I'm asking for a variance for the roof line to extend over my current stairs. We are in the process of adding a roof or and enclosing our front deck because the sunlight has just roached the wood, and the 4-foot stairs to the left of the house have been left out into the sunlight, and they are very, very crispy to the point to where someone carrying substantial amount of weight would be in jeopardy because the stairs would fall through. So we're having to redo that. And in doing this, I wanted to just simply take the roof line out over the stairs and cover them, protect them from the rain, the sun, the elements. And that's that.
There's a picture that you all have in your packet towards the end that shows the, we'll call it asymmetrical roof line. And then you can see how it covers on the right. And we're just simply asking that it be symmetrical like the side on the right. That's page 22.
So you're gonna extend the roof by how many feet?
It's gonna be a total of 4 feet, but it's already like 18 inches. So we're essentially asking for another foot, or it's gonna penetrate, to kind of back into it. The side setback is 8 feet, and we're asking for 3 feet of that 8 feet of that zone. Yeah, thanks. Okay, I didn't, yeah.
Thanks,
Oh,
Brady.
and the picture was there
Yeah.
too.
So the left side of the roof will match the right side?
Correct, yes,
It's
ma'am.
not
We're
gonna
trying to
be
keep it
different.
symmetrical looking instead of womp-sided. And I know it's one of these things you maybe have to see the property. This is a, what I call a quintessential Long Beach cabin that was built in '91. And to the right, there is a, I don't remember the math for the historical oaks, but that tree to the right of the house at chest height is 81 inches. So I think that it fits because it's 81 divided by 2, something like that. And I think that's why the builder back then decided to set our house 7 foot to the left, off center of the property line.
So do you have any reason why you can't put steps on the other side that already has a roof line out there?
We have steps over there. They're 3 feet wide, and the ones to the left are 4 feet wide. And I'm wanting to cover those, again, because the wood just gets roached in the sun. Our house faces due east, due west in the back. I have an 87-year-old mother-in-law who, thank God, she's fit right now, but the days may come to where we're gonna probably have to add one of those stair lifts, which would be on the left side. Can't put it on the right because I only got 3 feet, really like 35 inches between the rail and the house. So I can't encroach on that. I'm wanting to cover this for that reason and to protect it and to make my house look symmetrical, or our house.
Have you considered alternate materials like Trex that doesn't deteriorate like wood does?
I have.
And that you can't use that?
Well, Trex generally is available in a 1 1/4 thickness, and that's not, some of it's solid, a lot of it's not, but one of the things, and this is kind of gets into personal, I don't like Trex. It gets very, very hot in the summertime, and you're not gonna walk on it barefooted. Wood, on the other hand, just, you can, it's palatable.
Are you going to extend the roof the entire depth of the house or just over the steps?
Over the steps and the landing.
We have a
About half the house.
Probably a little bit more than half, but yes, sir, I think that would be a pretty good estimation.
We have a packet that has what we're doing, but this is a picture, and we have packets for y'all, but we're covering it this way, and it'll look kind of just like it does there, very asymmetrical. if
Is that a
it's,
picture we do not have?
I don't think so. We
Yeah, go ahead,
provided it.
pen in
I've
the
got
packet.
some if you want. I can.
Good.
Ms. Beck, will you provide a copy to Mr. Golden first for him to review very quickly?
That is everything we submitted. There's 3 or 4 pictures in there that weren't included. They're pictures of, I think, what Mary Ann's bringing up. It's another house that we're using for our template or guide on the front porch. But there's also pictures of the steps. As poor as those pictures are,
And just for Mr. Eads' benefit, I'll let him know that the applicant is passing around pictures that have been distributed to Mr. Golden as well.
All right, and once the board, thank you, Madam Clerk, once the board looks at those pictures, can they get at least one copy? And walk through that, Lisa, because that will be Exhibit 3.
Can you say that again? You were fading out a little bit. You want me to walk through what the packet of material includes?
Yes,
Okay.
if they want that into evidence,
Okay.
we just check it.
There's, it starts with a copy of a letter that they received from the town. There is a GIS map with their lot highlighted in blue. Copy of the application that they submitted to the town. And Mr. and Ms. Beck, please correct me if I mistake anything. There's also a variance application, required justifications that has some additional notes than the one that is in the packet, it appears. And then there's also a map of the property. And then the next page, not sure what I'm looking at there. Oh, it shows the current roof line. Looks like taken from above the house. There is next a picture of the property. Two pictures of the house, followed by a picture of the stairs. Sorry, 2 pictures of the stairs. And then there is a map, and if you'll help me indicate, what does that indicate on that page?
The circled part is where
that's,
we're asking.
Okay,
That's
there's
the-
a
The
map of the
setback
property
area.
that shows where the setback encroachment would be. And then there's another picture, the final page in this packet is a picture of what the completed house would look like, the completed project.
It's an example of what we're trying to do on the front.
Do we need a motion to accept these into the findings of fact?
Yes, so it would be Exhibit 3
Well,
that they're
just-
introducing.
So moved.
Yeah, so Ms.
Is there a
Sykes, the
second?
I'm sorry, go ahead, Mr. Eads.
the second to last page, there's a circled part that shows what they propose to do.
Yes.
And why they need this variance.
Yes, that it shows the area where the setback would need to go.
All right, if you don't mind, if you just count out the number of pages and what picture that is, and
Okay?
it appears staff has no objection, so I recommend we receive that packet as Exhibit 3.
That page that you just asked about is identical to page 20 in our packet.
Yes.
You get that, Counselor?
Yes, sir.
And there are 15 total pages.
Thank you.
Staff has no objection.
Again, did we?
So if we could have a motion to receiving evidence, that packet as Exhibit 3, the 15 pages.
Yes, Mr. McClendon has made a motion to accept that.
15 pages.
Okay.
As Exhibit 3.
Second?
All in favor?
Aye.
Okay, it is accepted in everything. Can we close the evidentiary hearing at this point?
We'll close it, but we may want.
Questions?
Again?
Does anybody have any questions?
I've got a question.
Yes, one more question?
Can you tell me what the actual hardship is? Because I'm struggling with, I've got open decks on my house, and we either paint them or we replace the wood.
Well, again, I'm wanting to, the deck is not in question, the coming out. That's getting covered. It's the stairs to the left of the house. I would like to cover them to protect them, and then also be able to add a stair lift there for someone who can't make stairs by themselves. And as opposed to just doing all this and then a year from now or 2 years from now, having to come back and ask for a variance and covering that section, I just thought I'd do it now. And also to provide symmetry to the house, which is aesthetics and just better for everybody, for me, for the tax base, for everybody on the road.
This property is a little bit unique in that it was not, the building wasn't placed center in the lot in the first place. Like he said, I'm either assuming that it's because of that big oak tree that they were trying to preserve, but also it's alongside of an alleyway, so maybe they were thinking it would be better to offset the house on the lot a little bit to keep it away from the alley. So if we were on any other house on that road, it wouldn't be an issue because we'd have enough room on both sides. But it's like 23 feet over on this side and 9 feet over on this side.
The house literally is 7 feet left of center on the lot.
The board have any more questions for our applicants? Hearing none, thank you very much.
Thank you.
Before we close the hearing.
I think the board
Ms.
will
Stites,
now
is anyone else
deliberate
signed up?
amongst themselves.
No, sir, nobody else had, there's nobody else here to speak to that, no, sir.
Okay.
Is there anyone else here that would like to speak? No one who hasn't been sworn, anyway.
Comments? I'd like to make a comment. I know that the deck staining and treatment, I have done it. It's like the Golden Gate Bridge at times, but you have to do it to maintain the wood. The other thing, and we're oceanfront, south facing, so I know about sun and wood. The other thing I would like to comment on is on a second row home on West Beach. I have seen a stair lift on their front steps, and they have it covered with a cover, and it's still there. And I don't know, there's also the option of having a lift, which is allowed to be, if I understand correctly, is allowed to be in the setback
With a variance.
Right.
versus a,
And we typically grant those for people who are handicapped.
have disabilities, correct? Yeah.
I can speak to the encroachments. For mechanical equipment, and lifts are included. They can encroach into all setbacks up to 4 feet. But specifically for lifts, in the front and the rear setback, lifts specifically, you can go 5.5 feet. That's the difference between the different setbacks and the allowable encroachments without a variance.
So theoretically, they could put a lift in the front of this staircase, and that would bring them up on the front left of this porch.
If they needed to, yes, they could encroach up to 5.5 feet into the front setback
Okay.
with a lift, yes. Without any kind of granting of a variance.
Okay.
That's all from the ordinance.
Thanks.
I'm not seeing the hardship. I'm sorry.
I agree.
I mean, this is, everybody down here is in the same boat, except for the house being lopsided, but
Shall we close the hearing at this point?
I think we should, well, I think we could deliberate, make a decision, and then close the hearing. Because just at any point, if we have a question, you know, if we would have to reopen the hearing in order to ask the question. So I think that's why we want to, you know, just
Okay, well,
procedurally.
we have several members that seem to see that one of the factors that must be met is not being met. So where does that leave us right now?
Well, I think if we were to just specify which factor, which of the four required factors was not met, then I think we could vote either to grant or deny. But if a majority feels that one of the factors is not met, then we must deny the variance. So I think if we want to either go through all the factors, or if we want to specify one factor that we agree, or at least.
It does not meet.
Right, it does not meet. So, John, you had a suggestion?
The law is very clear on this. Unnecessary hardship are the words.
Ed, what's your opinion on that?
I don't see a hardship.
Now, it seems like the majority of the board, including the chairman, doesn't really see this meeting clearly the hardship, and with that sad fact in evidence.
Well, then, I think we should I'll make a motion that this variance request does not meet the requirement of, that the board does not find that there is an unnecessary hardship justifying the variance.
I'll second that.
You got that recorded, Lisa?
Yes, sir.
Okay. All in favor of that motion?
Aye.
Aye.
And
And therefore, given that the, one of the necessary requirements is not met, I move the board deny the variance.
Second.
all in favor?
Aye.
It's my sad duty to inform you that your request has been denied by this board. You may appeal it through Brunswick County Superior Court, but that's it.
Are we good, Mr. Attorney?
I believe so.
Next case,
Stood it correctly. There was a motion,
next case, Mr. Golden.
Did we close the hearing?
Close the hearing.
Close the hearing.
Motion to close the hearing?
All in favor?
Aye.
Hearing's closed. Now we will open a new hearing on the next item, 11.2 variance 6404 East Oak Island Drive. Mr. Golden?
well, real quick, Mr. Chairman, the same rules apply to this variance as did the last. So if I could just ask a few questions, interest in the subject matter of this application.
Yes.
Well, this matter involves a restaurant on the main street, so I think if you were gonna ask if anyone's ever ate there, they would have to answer probably yes. That's my comment.
Many times. Many times.
I think it's important to go through the questions, so
Okay.
please do.
Does anyone have a financial interest in the subject matter?
No.
No, no one does.
Okay, and as I believe Mr. Chairman just indicated, I'm sure you're familiar with this site, but has anyone made a visit to this site for the purposes of assessing this application?
No.
No one has.
Has anyone had any conversations with staff about this application outside of this hearing?
No.
Yes, I have. I had a brief conversation with Mr. Golden about the ordinance as it might apply to this application. There were no conclusions drawn. I don't believe there was any prejudicial discussion, but I did have a brief discussion with Mr. Golden a couple days ago about the ordinance as it might apply to this particular application.
And I myself had one question this morning for Mr. Golden. I asked, historically, isn't it correct that a fence that high has never been approved by the Board of Adjustment? That was my comment. That's it, Counselor.
Was there anything about those conversations that would prevent you from being fair and impartial and base your vote solely on
Absolutely
the
not.
evidence?
I do not think so, no.
Same for Mr. Uhas.
Okay. Thank you for disclosing. Applicant, have any questions of these two board members concerning those conversations?
Applicant replied no.
Okay. All right. Can any of you think of any reason why you can't be fair and impartial? I mean, I asked that question kind of as a catch-all because I understand that
No.
at least two of you, if not, is there anything about the fact that you patronize this business would prevent you from being fair and impartial?
Unanimous no.
All right, all those who wish to testify must be sworn in. They will be subject to questions from the board as well as cross-examination. We'll proceed in the same manner. We'll hear from staff, then the applicant, then any other party withstanding. So, Ms. Stites, if you want to swear
Yes, sir.
the witnesses in.
Place your left hand on the Bible and raise your right arm. You solemnly swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Mr. Golden, you may proceed with your report.
All right, thank you. Item 2 will be application for a variance for a wall/fence structure, 6404 East Oak Island Drive. Some background on the situation. Subject property again, located at 6404 East Oak Island Drive, tax parcel ID 236 PF002. The property is zoned Community Business CB, and the request for variance is to exceed 2 to 3 feet over the 6-foot maximum height restriction for fences and walls on commercial pieces of property. And section 7.8.2 reads, fences not exceeding 6 feet may be erected only inside or rear yards. That applies to both, for standard fences, applies to both commercial and residential properties. Here is a map of the area north of East Oak Island Drive. Here is the zoning map. There, like I said before, the property is zoned CB. There are some R6 manufactured home zoning, other CB businesses, and some R7 and R6 further away. Here's a picture of the area of the property from January of 2024, before the violation was constructed. And here's a picture from June of the area in question.
And which one of our inspectors noted this?
I believe Dave Emerson?
He's not here today.
No, sir. Once again, here are the standards for the variance. If you have any specific questions about the standards or any other mentioned areas in the presentation, I'll be happy to answer any questions.
The board have questions for Mr. Golden, I'm sure? No? No questions?
Thank you.
Not at this time.
Say again? Not at this time.
Okay.
Would the applicant like to take the stand?
Well, Does the applicant have any questions of Mr. Goldman?
Yes, does the applicant have questions to direct at Mr. Golden? Not at this time, Counselor, but he reserves the right.
I think we need to,
Okay.
we need to enter the packet into evidence.
We need to enter it, findings of fact, accept it. We have a motion and a second. All in favor? Fine,
I just want to clear, that was the motion to accept the pages of the agenda packet as Exhibit 1?
As Exhibit 1.
Okay.
Exhibit
Thank you.
1.
And we need a similar motion for the PowerPoint.
It's pages 10 through 17.
So moved.
As Exhibit 2. All in favor?
Aye.
Okay, I think we got the findings of fact loaded into the record. And no questions further.
Thank you.
Now, the applicant will take the stand. For the record, your name and address.
My name's John Spencer. I'm one of the owners of Salt 64 on 6404 East Oak Island Drive.
And you live elsewhere.
I
Okay.
live on West Oak Island Drive. But our intent in erecting the wall, I guess, we didn't consider it a fence because the poles were existing when we bought the property, and we've experienced quite a blowback from diners in the west side dining room in the afternoon, as far as sun going right through the windows. We put cedar louvers on the windows, we tinted the windows, we put sail shades up, and nothing was working. Our intent long-term is to permit and tear the patio down and extend that dining room anyway. So we were trying to build a sunblock. We didn't acknowledge the fence ordinance, to be honest with you, because we didn't think we were building a fence. And we were just trying to protect the new AC equipment on that side of the building and block the sun coming in. That's really about it. But we wanted something that matched the structure that was already there, so. That's, answer any questions I could for you.
The board have any questions? I just got a comment that we don't normally look kindly when people come ask for variance after they've been cited for a violation.
I understand
It's
that.
customary to do that
I
ahead of
understand
time.
that. We didn't, yeah.
Well, I have, I guess, some questions, comments, and this, the CB district is a zero lot line district.
It is.
You can build your building right up to the property line.
Yes, sir.
And if you were to have a structure that is part of the building, it need not be, I don't think, entirely enclosed in order for it to be considered.
Right, and we're having architects and engineers work on that because of the existing building. Attaching to it is not exactly a simple task because the front part is a facade, and then the rest of the building slopes down to pitch roof. So we're working on that to get it submit permits and build. Actually, we're going to build short of short of the property line because Jeff and I both would like to have a nice little walkway back to the parking lot, so we're gonna.
I understand, but as a, let me call it a temporary measure. If you were to attach this wall at its top to the existing building with a number of beams, for example.
We could do that, pergola type, yeah.
Yeah.
we
Would
could
that
certainly
not,
do
and
that.
I will ask Mr.,
If that would fall within the
Would-
parameters of what we need to do.
would that now not become part of the building and then meet the requirement? I mean, it would, there would no longer be a need for a variance because it would become part of the building.
Yeah.
Mr. Golden takes the stand. Go ahead.
So like mentioned before, the interior side setback in the CL, or excuse me, in the CB zoning district is 0. So yes, if with a building permit, reviewed plans, and approved plans, we could permit meeting all building and zoning ordinances. We could permit an addition that could connect the existing structure to the building, making it part of the building and meeting the setback for an addition.
Right.
At this point, is it too late for the applicant to withdraw his application?
The variance application, yes, sir. But we could, from here,
Well, I
we,
mean, until the board votes on the variance application, they can withdraw it at any point.
Right.
I think that at the heart of that question is, if they were to reconfigure it, would they even need a variance? If I'm reading that question correct, if I'm understanding that question correctly.
Everyone get that?
yes, I would concur saying that yes, if the appropriate permits were filed, yes.
Right, so, I mean, it is conceivable, and maybe more than conceivable, it is, let me go so far as to say, likely that some modification of the existing structure, attaching it to the existing building, could be approved in a way that would allow it to remain until such time as the full modification of the restaurant was done.
Yes, sir, I believe so.
All right, so let me ask then of the.
If I can just interject here, that would be beyond the purview of the Board of Adjustment, though.
I
Yes,
didn't
correct.
hear that. What was that?
That would be beyond the purview of the Board of Adjustment. You're
Oh, yeah, it's absolutely.
sitting here today and whether, yeah, okay.
Right.
My only concern there would be because the permitting expense and process to just turn around and do it again, to make that a more permanent structure, the patio has to go, because it's not, yeah.
You are aware of your options, though.
Yes, sir, yes, sir.
Okay.
Discussion?
I'm wondering if there's a way, I know it took a while, but Shagger Jacks has the jasmine growing up. It's a plant
Right, yeah.
material
and-
growing up. If there's some way to even just get faux, they have screens that are filled with fake vines, just as a temporary thing.
We can certainly do that. Yeah, we really didn't, yeah, like I said, we weren't aware that we needed a variance to do that to begin with. And, yeah, that falls on me, that's my fault, I guess, but we just extended it to the top of the poles that were already there.
I get it.
Yeah.
Do you have a timeline to expand the building itself?
I hope to start before the end of the year and build outside in, and so that we can just connect.
So this wall, the top part would be coming down
Yes, ma'am.
at that point in time?
Yes, ma'am. And with any luck, I'll have engineering drawings within the next month, so, well, then I can get the permitting, but.
Any more questions from the board?
Kind of a procedural, are we allowed to delay?
I didn't hear what?
Are we allowed to delay the,
You mean table this?
yes?
I don't think so. How about that question, counsel?
Well, that would be up to the applicant. If the applicant wishes to withdraw, for lack of a better word, table or postpone their pending application, they can request that.
And then submit a
What
permit.
what would that do for enforcement of the violation?
I would contend that if they withdrew their application, then enforcement would move forward.
So I'd have to tear it down to rebuild it, to tear it down and rebuild it again.
Yeah.
I think I'll just, yeah.
Well, that sounds like a hardship created by your actions.
Yeah. All right.
Well, I mean, if they're considering, and I'm not giving the applicant legal advice, but if they are considering doing something that would not require a variance, then that's their option. If they want to talk to staff about that, if you want to take a brief recess to allow them to talk about that so they can assess their options.
Sounds-
The applicant wants to move forward now, unless there's any other evidence, you can start your deliberations.
Let me interject real quick about violation procedure. It's all based on time. So, whatever is ample time for, or not ample time, but reasonable time for the person, property in violation to come into compliance. I believe that this violation was noted a couple months ago. So without issuance, or excuse me, without application for a variance request, by this time, it would have already reached the end of the violation period, and then it would be turned over to legal counsel for further legality, for turning it over to
Enforcement.
well, the enforcement with the town at that point's done. It goes to our attorney for him to deal with at that point. So it gets out of our hands before. So if this violation were to be, or excuse me, if this variance were to be rescinded, then there wouldn't be any more time allowances for the applicant unless granted by our Board of Adjustments.
So I'm hearing you're suggesting this board take a 10-minute recess? Is that what you said?
We can do that if that's what you would prefer.
That doesn't have to be unanimous. What's the board's pleasure on that?
What's the purpose of a recess?
Okay, no. No, we'll continue.
Yeah, I don't really
Well,
know what else to say other than, we are planning to, take it down and rebuild the entire structure, but
Mr. Uhas?
based on
I
permitting.
just, I'm concerned about granting a variance in a situation where there is a legal way to come into compliance.
Can we offer a variance with a time limit so that he has time to come into compliance?
Doubted. Was that a question for council?
Yes.
Well, I don't, and I don't think that's appropriate for purposes of a variance. I mean, either you issue a variance, need to take any further steps to be compliant because
Can you speak up, Mr. Eads?
Yeah, we can't hear you. And you got normal hearing, right?
Okay.
Got no decision on that. Should we just continue on?
Are you there, Mr. Eads?
We could have gone to lunch.
I think he's probably talking.
I did want to hear what he said.
no, I mean, as the variance application is pending, then it is the board's duty to act on it one way or the other.
Yeah.
Understood, thank you.
Yes, sir. Thank you.
I'm not seeing that we have a whole lot of room here because the applicant can't withdraw his application
Well, no, the applicant could withdraw his application
right now.
right now.
Until we
Until we have voted, he can withdraw his application.
But then the
And-
enforcement can start.
Well, and,
puts us into
yeah, the enforcement will start, and the potential enforcement is, I believe that there's a daily fine for not coming into compliance.
What's it, $50 a day?
I don't know specifically what the fine is, but I know there's a fine. I don't know what the policy would be with regard to the fine. If there was an attempt to come into compliance through another means, whether that would toll the fine or not.
You mean if he applied for a building permit? Yeah.
I don't know what the policy is with regard to that.
That would be my question as well. What, if we applied for a building permit, what does that do with the enforcement and fines? And if, if not, I'll take it down as soon as it stops raining.
Who has the answer?
Well, that's beyond the purview of, staff always does with property owners and citizens of Oak Island. They will work with them. I don't want to speak out of turn here, but if there's a effort to comply, I think that the enforcement side, but it has to be something that's concrete and ascertainable. It can't just be a promise with no action.
Right. Absolutely. I would, we're gonna do whatever we need to do to make it right. I just, I don't see the permitting process and the construction of it as simply as getting a building permit and doing it because of the eave structure and the roof line structure. I'm not even sure without building permit or without an architect if I'd have proper clearance for fire code. To put an awning out there. That's why the sail shades are attached to the very top of the facade.
The board has examined your application and it's not looking likely that it's going to be passed. So where does that leave us?
Leaves me with taking it down.
That is possible. You could take it down and then you wouldn't pay any fines, correct, Mr. Golden? You need to speak with Matt on this, or?
I'd have to speak with code enforcement, whoever wrote the violation and what's currently pending.
But it's not likely. He hasn't gotten a letter from the town yet, has he? Oh, he has.
Yes.
That's
Yeah,
why
this-
he's here
this was-
today,
Yeah,
huh?
this was a discovery violation. This, yeah.
Okay, yeah, that's right.
Well,
That's nice. Send it to him on 9/11.
Okay.
What's the board's pleasure at this point?
Go ahead and vote.
Should we go through the different,
I think we,
Things for
I
the
think we
variance.
should look at the four requirements and see how we,
Put up on the screen.
We can go through the 4 requirements.
It's the hardship one, again.
Yeah.
well,
We'll go-
and I think it's more than just a hardship one.
Yeah,
you know,
okay.
If it fails on the first.
All right, I'll go through the standards.
All right.
160D-745, subset D, variances. When unnecessary, hardships would result from carrying out the strict letter of the zoning regulation. The Board of Adjustment shall vary any of the provisions of the zoning regulation upon showing all of the following. Number 1, unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of the variance, no reasonable use could be made of the property. Number 2, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability.
Before we go on to the next page, shall we discuss these two?
Before we go on to the next page, let's discuss the first 2.
Yeah,
What do you think?
I think that's a good idea. So, unnecessary hardship,
I don't find it.
Don't see it.
I
I do.
I mean, I can see that it is a hardship, and, whether it's unnecessary, I mean, I do think it's kind of an unnecessary hardship.
I think that it's not like he's abutting a neighbor, a residence. This fence abuts a parking lot. I generally think that is a hardship, and I don't think that this really kind of fits in with what's already there. I just don't see why he would need to pull it down,
It's,
even if it were gonna be there forever and a day. But the juxtaposition with if he puts a building permit to expand, he could be right up there.
So the board feels that number 1, it doesn't really meet that.
I think it does.
well, I think an argument can be made that it is an unnecessary hardship, because it does adversely affect the commercial viability of this particular property. And I think, given the commercial nature, and the necessity to be able to appropriately use the facility, I think that, arguably, it's an unnecessary hardship, because it does.
But
It's
it could be
unnecessary.
resolved other ways without a wooden fence. I mean, we're talking about 3 months, okay, put up some, I've got, on my deck, I've got shades. I drop them down, I put them back up.
What are your feelings on it, Ed?
Honestly, I'm kind of neutral because I see both sides. I don't, just don't want to get hung up on this number one.
Yeah, we'll have a vote later, so.
Yeah.
Well, if we go on to number two, however, let me say that I don't think that the conditions are peculiar to this property. I think all the properties on the island, have the same potential. There's glass, there's windows, there's sun, there's,
Yeah.
so I don't think from that standpoint that the conditions are peculiar to
Yeah,
the property.
we all moved to the beach to see the sun, not to hide from it.
I'll pull my shades down.
I'd beg to differ when you're sitting in that dining room, how many complaints you get. Yeah. I moved back to the beach to see the sun too.
Just not that much.
Just not that much.
From a technical Board of Adjustment standpoint, however, I think that, when we look at how we apply these things and where the kind of uniqueness of conditions that we're required to find, that this particular property doesn't have anything that is remarkably different from other properties on the beach in this area that would say that you deserve to have a higher fence when other properties don't. I just don't see it on this particular property.
Now revert back to question one.
Well, and I think we could go to the next page.
Let's go to the next page.
That's where I got hung up at.
Hardship did not result from actions taken by the applicant or the property owner, the act of purchasing property, with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship.
Well, I would agree that the hardship did not, there's not anything in particular that the applicant did that create this hardship. It's not a self-imposed hardship.
Nobody disagrees with the vice chair. Number 4, the requested variance is consistent with the spirit, purpose, and intent of the regulations such that public safety is secured and substantial justice is achieved.
I agree with 4.
It's consistent with that, but,
Well, okay.
safety and justice is not having a shady meal.
Well, if we look at the spirit, purpose, intent of the regulation, that is the regulation on the height of fences. What is the spirit, intention, purpose of that height requirement for fences? And does it really, are we violating that in this particular location, in this particular circumstance?
The purpose is uniformity. I don't think anyone has a fence higher than 6 feet on island.
Well, I think we actually granted a variance to allow a fence higher than that.
I know when I was on the board, the man made a good argument for it, but he didn't get it.
Or did we not? I can't recall. There was a fence behind that was around a pool.
A certain time in the afternoon, but anyway, the point.
The St. James, or,
The condos at 58th Street,
yeah, something, I maybe,
but I don't think it was higher than 6 feet. if I
Okay.
remember correctly. I'm sorry, I should be.
If I can interject, it was a couple meetings ago, there was a fence that was in the front yard that was 6 foot tall. So it was a granting of
a variance.
6 foot tall fence where it shouldn't have been, but it didn't exceed 6 foot.
That's exactly right. Yeah, that was recent, actually.
And also, there is an allowance for chain link fences in the CLD district that can go up to 10 feet tall, but only in that zoning district and only for chain linked fences.
Okay, correct. And that may be what I was thinking of.
Well, at this point, the board should entertain a motion to deny on one of the criterias. Of course, if I don't hear anything, that doesn't mean you're approved.
Can I ask about the wall up in, is that private residential house in Kings Lynn? That was built, I don't know, 5 years ago or something? It's between the new build, the house, or whatever the guy built, and the adjacent neighboring house. That's like almost 2 stories tall. Do you know what I'm talking about?
I believe that was an instance before I came on to work with the town, so I'm not familiar with that situation, but also this is the situation solely focused on this property.
Okay, so the intent of the spirit and purpose and the intent of the regulation, is it for uniformity? Or I always thought that it was so that you didn't block view of traffic.
Can't be for uniformity, because then everybody would have to have a fence. But it's to keep our open spaces open.
What is the intent of the regulation?
Well, I think that's right.
Thomas was here and tell you so the fire department could lay a hose on your house.
It's to keep, I think you're exactly right. It's to keep the open spaces open so that nobody's view is blocked.
And the fire department could squirt water on a burning house.
That may be. But here in the district where you're allowed to build right up to the lot line, you know,
That's really pointing to expand the building, yeah. And don't build a window in the sun, yeah.
Oh, there won't be one when I rebuild, you can believe that. Just gonna have to miss out on the sunsets and enjoy dinner.
Brady will promise they won't require that.
But if it makes any difference, we were really building a wall. We weren't even considering it a fence, yeah. I have a nice picture of sunset on the wall.
It's a tough call, but we're asking for a motion to deny on one of the criteria.
you're asking for a motion to deny.
Okay. You're still fighting for a way.
I'm still, I think, I will make a motion that this application does, what did I argue? That it does not meet
This application does not meet
the second
the second,
criteria. I think that was what I said, isn't it?
yeah.
Can we flip back to that?
I thought it was the first.
This application does not meet the second criteria.
Right. That would be I will make a motion
I'll second that.
And that has been seconded. All in favor of approving that motion?
aye.
It's unanimous, and now we need a motion to close the hearing.
No, we need a motion.
Motion to deny.
I'll make a motion that, given that one of the required variance standards has not been met, the Board of Adjustment denies this variance application.
Have you got that verbiage, Lisa?
Yes, sir.
Okay.
And just to be clear,
It's been seconded.
Yes, sir.
We're about
for the
to vote,
minutes,
yeah.
two is criteria two,
Criteria 2.
that it's not peculiar to the property.
It is, the hardship is not peculiar to the property.
Okay, I just want to make sure the minutes reflect that.
Right.
And I did not hear who seconded it, I'm sorry.
That's me,
Thank you.
or him, whichever one.
Okay. Sorry for the interruption. We can vote now?
Yep.
Okay. Vote yes, yes, yes,
Yes?
yes. Did you vote yes?
I did vote
Okay.
yes.
It's unanimous.
Motion to close the public hearing?
Okay, all in favor?
Aye.
Motion to adjourn?
Second.
Second? We're adjourned.
All right. Yeah.
All right, thank you, Mr. Chairman and board members. Apologize for my transportation issues today.